All right, you're Cynthia Campbell.
Yes, ma'am.
I got it now. Thank you. And will your client waive the formal reading of the motion?
She does, Judge.
All right, let me get my stuff together here. Ms. Campbell, in cause number 22-402, have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 12th of 2022 for the offense of aggravated assault with a deadly weapon. And that was a 10-year deferred probation. Is that correct?
Yes, Your Honor.
I'm getting there. It alleges that you violated your probation. Count 1 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically avoiding association with any person previously convicted of a crime or being at any location where a crime was committed. And is that true or not true?
Yes, Your Honor.
True or not true? Thank you. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your new address. Is that true or not true?
True.
Count 4 alleges that you provided a urine sample January 6th of 2025 that tested positive for methamphetamine, amphetamine, cocaine, and tetrahydrocannabinol. And is that true or not true?
True.
Count 5 alleges that you provided a urine sample January 8th of 2025 that also tested positive for methamphetamine, amphetamine, cocaine, and tetrahydrocannabinol. And is that true or not true?
True.
Count 6 alleges that you failed to successfully complete treatment at the Melton Center for intensive inpatient treatment. Is that true or not true?
True.
Count 6, that you failed to submit to alcohol or drug screening November 16th and December 9th of 2024, and then January 7th, January 14th, January 24th, and January 28th of 2025. And is that true or not true?
True.
And then count 8 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 8 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're all actually true?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And, hold on a second, I just lost it. There we go, okay. And it's for a term. Okay, state tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Campbell's not competent?
No, Judge.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, ma'am. You can go back with the bed.
The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
I speak on the,
Sure.
that case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed up off of my file, but it still shows up. That was not on me. It's somebody.
It's more than one time.
But I,
So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this.
Yes, ma'am.
This is Mr. Coleman's on Kaylin Thornton. Good morning, sir. You're Kaylin Thornton. And Mr. Thornton was previously in court in cause number 26 DCCR 0220, entered a plea of guilty to the third-degree felony offense of promotion of prostitution. I have received the pre-sentence report and reviewed it. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
The only correction, Mr. Thornton is working now. He
Good.
works for IHOP and at Main Event.
Okay,
So I know he said he was unemployed, but he is working.
good. Good. Anything else?
Based on the PSI and the lack of criminal history, I know the agreement was for straight probation. We were inquiring as to whether the criminal would consider deferred.
Mr. Smith?
Judge, this isn't my case, but I would defer to your.
I mean, I typically, especially for job purposes, depending on the nature of the offense, give that opportunity on a first. We've got no misdemeanor, no juvenile, no felony. It would make sense to me. Any issue?
I don't have an issue with it.
Okay.
Mr. Coleman might get mad at both of us, but
Well,
he's not here.
I can handle it. All right, sir, what I'm going to do then, based on that discussion, is modify this to a 10 deferred. All right, anything else then before I go forward with sentencing?
Well, he has a GPS monitor on. He's been having it on for quite some time.
And that was a bond condition, so
Yeah.
that would be, I think, I won't require that unless there's some issues with probation. So he'll be able to get that off later today or tomorrow. And as long as everything else is going well, that shouldn't be an issue. I'll go through with all the conditions and make sure that's all understood, all right? Okay, so Mr. Thornton, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for a period of 10 years. There's Mr. Coleman.
As I was watching upstairs,
Go
I
ahead.
asked that the court reconsider, Judge. This, initially, there was an allegation of violence. I don't know if the court will want to put this on a brief hold so that we can maybe take a look at the PC affidavit. I can also give you a summary. But not only was there an aggravated promotion of, excuse me, I'm out of breath because
No, take your
took the
time.
stairs down.
That's okay.
Not only was there an allegation that started out as a first degree aggravated promotion of prostitution that we have agreed to plead down to a lesser, but there was also an allegation that the individual or individuals who this defendant was essentially pimping were assaulted by this defendant, Judge. And I think under those circumstances, he's not. I think deferred would not be appropriate in this case.
So let me do this. Thank you for coming down, Mr. Smith. Mr. Coleman, give me just a second. I'm going to take a look at that.
And I would say that is an allegation. I'm not sure if Mr. Coleman has actually spoken with the alleged complainant. She's incarcerated, so maybe he could, or she was incarcerated as of last week.
Happy to have a sentencing hearing if the court
But
goes.
like I stated, for the reasons, there have been several types of cases where the court, for even, I would say worse offenses than this, where a person has had the opportunity with deferred probation when they do not have any prior criminal history. So we believe that that would be fair, in this situation.
Well, I mean, give me a second, because y'all did agree already, and
That's right, Judge.
that was what was offered, and it wasn't unagreed as to the type of probation. So give me just a minute.
Yeah, I want to clean up. So.
All right, I think I'm going to go along with that original deal. Thank you for coming down, Mr. Coleman.
Thank you.
Obviously, the allegations are very serious. So let me go back and do this. Mr. Thornton, you made an agreement for that 10-year term, and that's what we're going to go along with. And so I am again going to find sufficient evidence to find you guilty. I am at this time, in accordance with your agreement, going to find you guilty of promotion of prostitution. I'm going to sentence you in accordance with your agreement to a term of 10 years in prison, but that'll be probated. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That includes, you will initially be on the high medium caseload, which just means you'll be under a little more supervision so they can make sure you're headed in the right path. You will be required to complete the moral recognition therapy and pay the cost of that. Have absolutely no contact with Caitlin Whitsitt, and not be on the premises of 4150 Maida Road. In addition, no association or whatsoever with prostitutes in any way, whether they're willing or not. You cannot have anything to do with them. Do you understand? If you do everything you're supposed to, you still have an excellent opportunity because you'll be able to serve that 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you'll be brought back into court and you'll be facing that 10-year sentence that you agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Thank you, Ms. Holmes. Thank you,
Thank
Mr.
you.
Coleman. Good morning. Are you Erin Riley?
Yes, ma'am.
And this is 25 DCCR 1194. Ms. Riley's charged of assault of hospital personnel. And what is the announcement?
Your Honor, if we could have a little bit more time, Ms. Riley did provide me some documentation regarding her mental health status.
Okay.
This revolved around, that's why she was at the
Sure.
hospital that day, and I provided that documentation to the prosecutor. So we get some time to review that.
Sure. Any issues? All right, I'll just do a normal reset. Ms. Riley, make sure you stay in touch with Ms. Holmes and she'll let you know what she discusses with Mr. Smith and then when your next date is, okay?
Okay.
You're free to go. And then, Ms. Holmes, you've got Kaylin Thornton
Yes, sir.
sentencing.
3 months in. It was why.